Okay, well, we have had so much. I hope everybody listening realizes this is like an encyclopedia. I hate to say the word because we don't have encyclopedias anymore. Encyclopedia on the radio. This morning has been from UFOs this morning to gene therapy to vascular surgery and now, of course, we're going to do something really, really good that everyone needs, and that's an excellent elder law attorney. So good morning, Joe. How are you?
I am wonderful. Good morning.
Well, I have to tell you that I thought you were coming in this morning because our new administrator had coming in, but you're not coming in. So I'm going to say, don't ever put coming in if he's not coming in. It got me all excited.
Well, I'm sorry. I'm absolutely in the opposite direction. I am now in Manhattan, so it would be very difficult to me.
Oh, you're in Manhattan? Well, that even is more interesting. Okay. So now we're going to talk about some stuff, Joe. What is happening? We've had such cutting-edge discussions here this morning. Are there new laws? Are there new things that you know as an board-certified elder law attorney we should know?
The answer is actually what I do know is, forgetting about the new stuff, it's the basic stuff. I got to tell you, I just met a couple last night when Debbie and I were on the bus coming into Manhattan from LaGuardia, and they were very interesting. They were very nice. And we were talking about a basic. This guy is assisting a friend of his who is now in an incompetency proceeding in New York. And how this guy has been run through the system. And the guy is incompetent. But how the guy got taken advantage of and how much it's cost the system. And this friend of his is now involved trying to extricate it and handle it and spending fortunes of hours and time. And then the guy was telling me, he said, my father was a lawyer, and he always said everybody had to have a will. And he was right. And I said, your father was right, but you're missing the point. You're sitting here talking to me now, telling me about all of these problems because this person had nothing to do with the will. That's what happens when he's dead. And you know what? If things get screwed up when you're dead, it's not the end of the world. Your death is the end of the world. But what really is a shame is this guy didn't have a power of attorney. He didn't have a health care power of attorney. He didn't have a trust. He had nothing to take care of him while he's alive. And he either didn't realize it, wasn't told it, or figured, when I get hit by a bus or have a stroke, then I'll do a power of attorney, which is, of course, absurd. And I said, all of these problems could have avoided if he had some paperwork in order authorizing you to assist him or anyone else that he trusted to assist him and to take charge. And he said the guy is cooperative, so any of these instruments would have worked. The only time you need a guardianship is when you have no authority or because it's like in a power of attorney and stuff like that, the person is still going off the deep end and acting in an inappropriate fashion, and you have no legal remedy to stop them. But most people, as his friend, are incompetent and just become unable to handle their affairs and would do whatever they want. Their loved ones or their trusted ones would do if their friends or loved ones had the authority. So he said, I got it. And then we started talking, and I said, what do you do? And I said, well, I practice elder law. He said, I've never heard anybody talk about this. Everybody's always talking about a will. And I said, well, elder lawyers recognize the importance of taking care of things when you're dead. That's critical. But we always put life planning and taking care of things while you're alive first. So I just want to remind people of that. That's sort of new because estate planners have always been death planners. And most people, when they come into me, where they call up, where they're checking in, they say, how much is a will? I need a will. And when you start to explain, even to a married couple, that, if your husband dies, you can get that $600,000 401k. But if he's in an accident and he's incapacitated, if you don't have a power of attorney, you can't access it. You're going to need a guardianship. Because they always assume, well, I'll get the power of attorney. Life doesn't just flow into death. Very few people have that. I assume one would think fortune or misfortune. I just know a gentleman who died last week driving to Publix. He stopped, had a massive coronary, and died. But that is the exception to the rule. So that's really what's new, is people forget what's more important is that taking care of yourself while you're alive and picking your cast of characters and having the right documentation in place and analyzing who's appropriate. That's the other thing that we do all the time. It's very interesting when you start talking to people that the analysis, the thought that goes into it, when you start talking about when they're alive, those are serious decisions. So that's sort of new.
Okay, well, let me jump in here and just ask you something. So when you first started as an elder law attorney, I don't even know how many years ago. Let's see, could it be 25?
20.
20.
Over 20.
Okay, 20. So it was more that we thought was just wills, trusts, but you now get into everything for that elder person that has to do with law, and even more. You have a social worker. You have so many things. The whole practice has changed, hasn't it?
Well, if you stand still, you're going to get hit by a bus. The answer is, and I thought it was ridiculous many, many years ago. Bill Gates wrote a book many, many years ago. I forget about it. It was a book that he wrote when he was successful. He was Microsoft, and he did. And his book talked about, and to me, it was absurd at the time, how afraid he was that Microsoft would be taken over by the next best thing, that they wouldn't keep pace and they wouldn't do whatever. And to some degree, although Microsoft is still a phenomenally successful and rich company, they didn't do Google. They didn't do the Internet. You can't stand still. And that's what the other thing people don't understand. And sometimes you sort of have to remind them that everything we do in life is evolutionary. We evolve. Situations change. We learn from circumstances. And we change what we do. So many, many of my clients, when they come back in, and they come in and they say, well, why didn't you tell me to do this 3 years ago, 6 years ago? Well, number one, you might not have been receptive. That's number one. Number two, I might not have thought about it, or I might not have seen it, or nobody had seen it. I mean, by example, today, I'll give you a what's new today. The Supreme Court, when you have an IRA, if you're sued, that IRA is exempt from creditors' claims. So that's a protected asset because retirement funds have been given by Congress a protective shield. And if you leave that IRA to your spouse, it's still deemed a retirement fund because the husband and wife were counting on it, and it's protected. A week and a half ago, the Supreme Court said if you're the beneficiary, not a spouse beneficiary, but another beneficiary of an IRA, it is not protected in bankruptcy court. So if you're leaving your IRA to your son or your daughter, and you have the belief that even though they are not exactly good with money and they will probably spend more than they have, and they may ultimately have to go bankrupt, or they have financial problems now, and you know that bankruptcy is a reasonable potential, then they inherit that IRA that's no longer safe when they end up in bankruptcy. Now, we have been doing IRA trusts, which are special trusts just for IRAs, for several years now. Will there be more of a push on it when parents now recognize the money is not safe for their kids? Sure. So these things evolve, and I'll have somebody come and say, well, why didn't you tell me about this IRA trust back then? Well, first of all, we've been only doing them for about 2 years because there were many issues with being able to do a trust for IRAs. And then we had to make sure we did it right. And the need was not as perceived by people. That people now recognize even successful children can run into financial problems. I mean, big companies go belly up, big investments go south. So now we think we'll see more of that. So that's an example of what's new. That happened in the last 2 weeks. So we end up talking about people and dealing with their issues, and we keep evolving. But next year, this time, I'll have a conversation with you about something that I don't even know what it is. Sometimes I feel like the White House. Who the hell knew that was going to happen? You know, you wake up one morning and there's a new spot in the world that creates a problem. Look, you wake up one morning and there's new changes that take place in our society. I mean, my column in Boomer Times this coming month, the July column, talks about something that flies in the face of what everybody believes. Everybody believes if you want to cut out a child, you should leave them $1, right?
Yep.
Don't leave them a nickel, because that only complicates life. You merely have to acknowledge that child's existence. So we do. I'm mindful of my son, Bob, but for reasons known unto myself, I make no provision for him or his lineal descendants. Now he's not entitled to a piece of paper. He's not entitled to an accounting. He's not entitled to make your life difficult. Well, when I look at all these older wills, they always leave Bob $1 or 100, because they used to say, well, you've got to show that you remembered him, so leave him something. Well, if you remember him, you can remember why you're leaving him nothing.
Yeah, you've told that to me a lot, and that's very, very important. I think that's one of the biggest surprises for most people in your column when you wrote that about, listen, don't even go there. If you don't want someone to have it, don't give them anything so that they're not a part of the estate. That was brilliant.
And lawyers never thought about it. And I didn't think about it when I first started doing estate planning, and I was doing wills. I've been doing them for 40 years. Everybody said, oh, always make sure you leave them $1. And lawyers would pass that down. And then the first time, and somebody who left their son a nominal amount, and that gave them the right to notice, and all of a sudden there was a lawsuit. Why? Because somebody gave him a wake-up call. He didn't even know his parents were dead. No contact. And all of a sudden he's challenging the estate.
Well, I want to ask you, though, excuse me, Joe, you have helped, of course, our family. You've helped a lot of my friends. You've helped so many people who read Boomer Times. And if you could run the clock back, and of course we can't do that, what would you say that was probably one of the most unusual cases? And I know you have a lot of them, but think about it for a moment and just... as I invite everybody to come to the Boomer Expo, get your brain together there. I know you're in Manhattan having a lot of fun. Don't forget July the 25th at the Seminole Hard Rock. I hope everybody will come. But Joe, you've done very unusual things for people that I think most lawyers, especially ones that they don't call themselves elder law attorneys. They just say, oh, we just deal in wills and trusts and you should come to us, which is so different than an elder law attorney that's board certified as you are. And also, I don't want to forget about your seminars. I think while you're thinking, let me just mention your seminars too, because you will get so much information from Joe Karp seminars, and mark it down in your calendar. They're free. And there'll be one on Tuesday, July the 29th from 1:30 to 4 at Port St. Lucie Holiday Inn. There'll be another one Wednesday, July 30th from 1:30 to 4, the Courtyard by Marriott in Boynton Beach. Another one on Thursday, July 31st from 1:30 to 4 at the Palm Beach Gardens Marriott. I cannot express my dedication and my urging you. Go to one of these seminars. He calls it a senior survival workshop. It is free. You will be with Joe Karp for 2.5 hours or probably more, and there are no reservations required. And for information, if you do need it, you can go to their website, which is karplaw.com. That's with a K, karplaw.com, or if you really need to call, it's 1-800-893-9911. You can read Joe Karp's articles each and every month. He's been doing this for so many years. And I mean, if you haven't gotten a legal education by now, something is wrong. Okay, Joe. So give us something in the, so people really understand just how far out this can get.
Okay. Well, I'll just say one thing, and I hate to correct you, but I will tell you something because you don't know it from my point of view. One thing I'm going to say is I made a prediction almost 20 years ago that has come true. I said 20 years ago that within 10 years, every lawyer who writes a will say they practice elder law because they'll realize that that is critical. So today, you will see numerous lawyers say they are elder law attorneys. They have not gotten board certification. They are using that almost synonymously with will planning and stuff like that. But it has now become a switch. True story, when the Yellow Pages came to me 20 years ago, and they wanted to list me under wills, trust, and estates, I said, fine. I said, what about under elder law in Palm Beach County? You know what they said to me? What's that? We don't have that heading. And the following year or two, they finally came to me and said, we now have this new heading called elder law. But they didn't even have the heading when I was asking for it.
Do they have it now?
Oh, sure.
Okay.
But now, the number of people who are listed that say they practice elder law is significantly larger than those who actually are true elder law attorneys, in my opinion, that understand elder law. They are will planners and stuff like that as well. But anyway, that's inside. The most unusual case, well, there's different stuff for different stuff. The fact patterns get so different. Probably the weirdest estate planning case I ever had, and it's reflective of the change in our times, and this is 10, 12 years ago, a woman who came to me who wanted to change her estate plan, and this is why. She had a daughter who was gay in California, had lived in California, who had a partner. They were not married back then. And she and the partner adopted a child because gay adoptions were permissible in California. They didn't adopt the child. The partner had the child through someone else, and she adopted the child from the partner, so the two of them were the parents. She and the partner then split up, but she was still an adoptive parent of the child, and the partner sued her for child support, and the daughter couldn't pay the support. The daughter then moved to Alabama and had no contact with the child or the partner, ex-partner in California. And she said, my daughter now owes her ex-partner child support for a child that she was neither the mother nor the father of. And I want to make sure I leave her money that the ex-partner can't get the money. And it was like, what a convoluted new world we live in that all of that occurred. that you could end up being responsible for child support for a child of which you're really not the parent, and you have no contact, and it was a gay relationship at the time. That was so unique and so mind-blowing. And now the mother said, I don't know this kid. I have no relationship. I don't want this kid to get any money. So that was weird on estate planning because the concepts were so new. This was 12, 15 years ago.
Really? That was new then.
Oh, yeah. It was like, how did this happen? You know what? Everybody's story is unique, and every family is so unique. I mean, I see so much stuff. It's all interesting. It's absolutely all interesting. Everybody has, remember the TV show, The Naked City, and they used to say there's, 9 million stories in The Naked City, and this is just one of them.
Right.
Everybody has interesting tales that their families are so interesting, and their stories are so interesting, and what they bring to the table. And that's why I learn from my clients. I learn so much from them about the world and about people. Sometimes they don't even know they're teaching me. Sometimes they do. They've got information, knowledge, experience.
So I have a question. We in the estate planning, do you ever discuss funeral arrangements? Because it's funny, I don't remember that you've done that with us. But Bill and I are going to use the science care, which is where they just take the body away for research. Is there something I'm supposed to come and talk to you about? Maybe that is true. We should put that into the documents so people know that's what we want? No, it'll be too late by then. It's too late by then.
Absolutely. And I'm going to tell you that I had this conversation with a client on Thursday.
Huh.
And it was very interesting because they do talk about with clients. They should put that. Well, first of all, the binder we give you says right down what you want, what you've done, and have this conversation. But I have this conversation all the time with people that it's something that should be discussed. And some people are hard to talk about. I mean, I finally got my wife to give me some feedback as to what she would want. She just Debbie doesn't want to deal with it. She knows what I do every day, and, it's sort of like the shoemaker's son has no shoes. If you can't get your spouse to talk about it, it's going to happen. Let's talk. I said, I want to do what you want if you go before me. I said, you know what I want, but I have two things. One, what I want, but the first thing I want is whatever works for her. Because if I predecease my wife, death and funerals are all about the living, not the dead. So it's what will make her comfortable and what will give her an ability to come to terms with the situation as best as possible.
Well, if I may just tell you to look up Science Care, I've really now very, very dedicated to that because, when you die, just in my opinion anyway, you either go in a box and then whatever happens to you there, or you're just ashes. But it'd be wonderful to think that your body's now going to be used. So because I've talked to so many doctors and they love their cadavers that made such a difference in their life. So anyway,
I understand.
I'm just throwing it to you. Tell Debbie I suggested it.
Use. I'm into recycling, so that's a good thing.
Right. I love it.
And the answer is, if you can't recycle because the parts are old and unusable, there certainly are education tools.
Yeah, right. That's a very good point.
I'll tell you this story with my clients. First of all, if you're going to do something that you don't think your family's going to want, you should put it in your will, you should prepay it, you should make it known, you should be written. But I had a client in Thursday, and we were reviewing their documents. It was a 3-year review. And she said, we've decided and we've prepaid for cremations. Is there anything we have to do about it? And I said, will any of the family give a hard time or oppose? And they said, oh, no, nobody really cares. What we do is fine. And I look at her will, and most of my clients put nothing about what happens when they die to their bodies in their will, because everybody knows there's no appointment, there's no need. But there are certain people who want to put things in. So if you thought your family would challenge your science thing, then you want to put it in so it's crystal clear that's your wish. The whole, if you remember the Ted Williams with whether we should freeze his brain or
Right,
not.
I remember.
But if he had it in his will, it would have been clear cut, and if he didn't write anything afterwards to challenge it. Her will specifically said, when I die, I want no autopsy and a traditional Jewish funeral. I said, I got to break it to you. Cremation is not only non-traditional, it is against the Jewish religion.
Huh?
And she said, I had forgotten that that's what I had wanted. I mean, no autopsy. I mean, very traditional. She wanted it because she wanted and now they have come to terms. I said, we got to change your will. You have prepaid for cremation, which is absolutely inconsistent with your will, and that could be a problem.
Wait, Joe, before we run out of time. So let me tell you the good part about this. There's no cost. Nothing. And if they take if you want a cremation, after about 6 weeks, they'll bring you back some of the ashes of the stuff they don't use to send to research and hospitals. So here they pick up the body. There's no cost. There's no age. I mean, it is so perfect for all of us, I think. And Debbie would like that. No cost.
Information on that?
I will. I will.
I'll keep it in my office.
I will. I mean, I just so excited about it.
Brochures in my office for good services.
Good.
And that's a valuable thing.
It is.
And everybody has their own beliefs, but anyway, let everybody have a good 4th of July.
Okay. And you too, and be safe up there. Have fun. And love to see you again. I'm forgetting what you look like, except your picture in the article. So we've got to do something about that.
Okay, we shall. Take care, be well. Happy
Thank
4th
you.
of July.
The same to you, Joe and Debbie. Bye. We'll be back next week, same time. Just listen to us every Saturday from 5 to 8 a.m. And then, of course, on Sundays, we have a 7 to 7:30 in the morning, and then a 4:30 to 5 on WNN, which is 1470 a.m.